In a shocking, but if we're being honest, not totally surprising filing, the Trump Department of Justice has come out in support of the National Firearms Act of 1934. In its filing, DOJ has asked the judge to deny our motion for summary judgment, calling NFA items weapons of war, and explicitly claiming that these items are particularly susceptible to criminal misuse. Today, we're going to be taking a deep look at the government's brief in our One Big Beautiful lawsuit against the NFA and what it means for gun owners. Hi, I'm Ben, and you're watching the Minuteman Moment. With the Department of Justice opposing us in our One Big Beautiful lawsuit, this fight just got a whole lot harder. Thankfully, at GOA, we're no strangers to doing the work and fighting for the Second Amendment. Please consider becoming a member to help us take down the NFA. Okay, now back to the video. On November 20th, the Department of Justice filed its memorandum in opposition to plaintiff's motion for summary judgment and in support of defendant's motion for summary judgment. Well, that's a mouthful, and a lot of summary judgment. Basically, translated from legalese, the Department of Justice is asking the court to reject our challenge to the NFA and to uphold the NFA as constitutional. Well, unfortunately for the DOJ, we disagree. We're in for a long fight now, but this is the fight that we intend to win. For those of you who aren't already familiar with our lawsuit, this situation stems from the passage of the One Big Beautiful Bill Act, which became law in July. During the fight to pass the bill, GOA lobbied hard in Congress and for the full deregulation of short-barreled rifles, short-barreled shotguns, suppressors, and AOWs, also known as any other weapons, from the taxation and registration requirements of the National Firearms Act. While the full repeal made it into the bill, an unelected bureaucrat, known as the Senate parliamentarian, stripped the removal of registration requirements from the final language. Unfortunately, at that point, all we were left with was a removal of the tax on these items. Of course, the National Firearms Act was enacted not as a registry of firearms, but as a registry showing that the tax payments had been made for those firearms. Plus, thanks to two different Supreme Court cases from the 1930s, U.S. versus Onsinski and U.S. versus Constantine, we know that a $0 tax, or a tax that does not generate revenue, is not a tax at all. This means that the so-called constitutional foundation, which the NFA stood on, no longer exists. Well, that's exactly what we said in our One Big Beautiful lawsuit, that we filed on the same day as the One Big Beautiful Bill Act was passed into law. Now, finally, after months of waiting, the Bondi Department of Justice has filed its first motion. And unfortunately, it's indistinguishable from any filing that we would have gotten from the Biden administration. Here's what DOJ has to say about our arguments. Plaintiffs claim that Congress's taxing power can no longer serve as the constitutional source of the NFA's requirements on manufacturing, transferring, or possessing short-barreled rifles and shotguns, suppressors, and AOWs, because those firearms are now untaxed after the OBBB enactment and therefore produce no revenue. But that claim suffers from an obvious flaw. Contrary to what plaintiffs contend, business in these firearms is not untaxed. While the OBBB zeroed out the NFA's making and transfer taxes on short-barreled rifles and shotguns, suppressors, and AOWs, the NFA still imposes a tax, namely the Special Occupation Tax, on businesses that import, manufacture, or deal in these firearms. These firearms thus do produce federal tax revenue, and the challenged NFA requirements support the collection of that revenue. That's a valid exercise of Congress's taxing power. Okay, let's break this down. The Department of Justice is arguing that, even with the NFA taxes being set to $0, the NFA is still a valid exercise of the taxing power because it still taxes the manufacturers who manufacture NFA firearms. That's like Congress repealing the personal income tax and the IRS demanding you still file a tax return on the theory that businesses still pay sales tax. This also flies in the face of history. The National Firearms Act levied the taxes on those items at $200 because that is the equivalent to nearly $5,000 today. It was a way to make those items so unaffordable that no regular person could possibly buy them. It had little to do with manufacturers engaging in commerce and regulating those manufacturers. And secondly, the manufacturing tax that the government is describing is the Special Occupational Taxpayer Form, also known as an SOT. Licensed dealers who deal in the NFA items are required to have these forms because they manufacture or deal in NFA items. What the SOT does in reality is it absolves dealers and manufacturers from paying each individual $200 tax per item, instead paying a flat $1,000 yearly fee. While the NFA tax on manufacturers remains in effect, it has little to do with the registration that remains on individuals who possess these items, and who now pay no tax on them thanks to the One Big Beautiful Bill. The government is trying to say that since other parts of the NFA generate different tax incomes, that must mean the whole thing is constitutional, including the registration for $0 tax stamps. This is a bad argument and it defies logic. But it gets worse. DOJ goes on to say that even beyond Congress's taxing power, Congress has the authority to enact the challenged NFA requirements under the Constitution's Commerce Clause. The government says that because the NFA regulates interstate transfer of firearms, even without the tax, the NFA is constitutional because it regulates commerce. This is an obvious move to justify the NFA beyond what even Congress intended. Also, if the federal government can register NFA items simply because they're moved in interstate commerce, then under that logic, a registry of all firearms, not just NFA items, is justified by the department's own logic. Finally, DOJ claims that the NFA is also justified by the necessary and proper clause of the Constitution. Think about what's happening here. Bondi's DOJ is arguing that the necessary and proper clause empowers Congress to make all laws which shall be necessary and proper for carrying into execution federal gun control laws. They even insist that Congress has broad authority to enact federal legislation like the NFA's gun registration scheme. So, the government essentially says that because of the necessary and proper clause, there's virtually no limit to what infringements Congress can pass. Those words are a blank check for anti-gun judges to decide that any firearm they dislike can be banned. They even say that the federal government can ban firearms that are particularly dangerous and uniquely susceptible to misuse by violent criminals. Really? Well then what about handguns, which are the #1 type of firearm used in crime? Can those be banned too? This is not the rule of law, this is judicial tyranny. And as you can see, we're in a battle for the soul of the Second Amendment. If Bondi's DOJ gets away with this, nothing will be off limits. To sum it all up, Pam Bondi's DOJ has taken perhaps the most expansive view of the scope of federal power since big government lover President Franklin Delano Roosevelt. But wait, I thought President Trump just got elected to rein in federal power and reduce the size of the government. So who in his DOJ is arguing that Congress has virtually unlimited power over every aspect of American life? If that wasn't bad enough, DOJ's filing is full of anti-gun buzzwords. In one example, the Department of Justice chooses to cite an opinion calling NFA items weapons of war, a term explicitly used by the gun control industrial complex.
By weapons of war.
Oh, weapons of war.
Ban weapons of war.
Weapons of war.
Weapons of war.
Weapons of war.
On weapons of war.
We shouldn't have weapons of war on our streets.
Why is the Trump Department of Justice citing cases using this language? Even so, weapons of war are the exact weapons that the founders explicitly protected by writing the Second Amendment. But that's not all. The DOJ continues by saying that historic laws targeting dangerous and unusual weapons mirror the NFA in their purpose. Short-barreled shotguns are uniquely attractive to violent criminals. The NFA's regulation of short-barreled rifles targets a concealable weapon, likely to be used for criminal purposes. Seeking to curtail armed crime, the NFA targeted particularly dangerous and easily concealable weapons that could be used readily and easily by criminals. That's a lot of anti-gun language packed into one brief. This is disappointing, especially coming from this administration. The Trump administration has done so much good on the Second Amendment. It's a shame that the Department of Justice continues to defend the patently unconstitutional NFA and wage war against our gun rights. Here's how you can help us fight back against the NFA. Call the White House at 202-456-1111 and demand that they drop their terrible arguments against GOA's One Big Beautiful lawsuit. You can also leave a comment on their website, whitehouse.gov/contact. I'll also link it down below. Of course, our legal team will be working around the clock to fight back against the DOJ in this case, and we'll keep you updated as it develops. Now thanks for watching. Be sure to like, comment, and subscribe to stay up to date with GOA's latest fights for your rights.